Bill number 108, the people of the state of New York versus Clinton Britt.
Good afternoon, Your Honors. Jenny Wu, co-counsel Legal Aid Society, here representing the appellant, Mr. Clinton Britt. I'd like to reserve 2 minutes for rebuttal.
You may, Ms. Wu.
On the issue of legal sufficiency, this case has already been decided 10 years ago by this court in Bailey. Bailey remains good law. The prosecution does not dispute that Bailey remains good law. Given that, Bailey requires reversal of this case because there is no meaningful distinction between that case and this case. There are clear parallels between the two cases.
You're saying there's no circumstantial evidence by which a jury could have reasonably concluded that indeed he had the intent?
That's
to
correct,
defraud?
Your Honor. That is our position, that there is no, that the totality of the evidence that was presented by the people at trial did not give rise to.
Assume that we accept that Agent Helms' testimony is properly admitted. I know you don't necessarily agree with that, but assume that we think it's properly admitted. Why doesn't that distinguish this from Bailey?
That's because that fact of separation only gives rise to speculation about the significance of the separation of the bills, right?
Well, I assume that your opponent is going to argue that the opposite inference can be drawn, right, from the separation of the bills. And under our standard of review, aren't we obligated to draw the inference in favor of the people, even in the face of competing inference?
Yes, but there are limits to that, and those limits have been crossed in this case. In that
The limits, I'm sorry.
There are limits to that deference that's given to the fact finding below by the jury, and those limits have been crossed in this case. And that's because here, the fact of the separation of the bills only gives rise to speculation as to the meaning of that separation. It could mean, as the people have argued, that there was an intent to use the bills that have been wadded up tightly by a rubber band. But it's equally consistent with an inference that having those bills tightly wadded up in a rubber band.
But if the jury found the expert's testimony credible, that this is a common thing that people who intend to fraudulently use counterfeit instruments do, then that gives them something from which they can decide, well, okay, did it or didn't it? You know, do we believe this expert?
So first of all, as we have argued, that particular expert testimony was inadmissible because it lacked foundation. But setting that aside, the fact of the matter is that looking at the testimony that Agent Helm gave, he didn't have the necessary qualifications, skill, or experience to provide a reliable opinion on that.
Aren't these arguments, excuse me, aren't these arguments really weight arguments, not sufficiency arguments?
No, this is about whether or not the evidence was such that you could
Let me
make
back
a
up a
rational
second.
inference.
Assuming possession does not equal intent. I agree with you about that. All right, so let's say that's what the statute says. There's no argument about that. Then we're really down to, is the evidence in the record sufficient? And you have a statement, you have the statement of the defendant and the statement of the expert getting past your foundation argument. That being the case, I'm having a hard time seeing why it isn't legally sufficient. I understand it as a weight argument, but as a basic sufficiency argument, with going back to the Chief Judge's question, aren't we kind of really bound on the sufficiency question?
No, Your Honor, because here, taking in points in turn, the statement given by the defendant only goes towards knowledge. It's not intent, and knowledge and intent have to be proven separately beyond a reasonable doubt. That's what Bailey
But can't the
says.
same proof be used for both? I mean, it's a separate proof.
It's a separate
requirement.
element, but it's the same proof.
Yes, but only if a rational inference can be drawn for that particular piece of
Oh, yeah, you're
evidence.
getting that, but the argument is presented, just like Judge Garcia was saying, the argument is being presented like you have to have proof other than the proof of possession. You don't. You have the same proof, and it goes to a different element.
That can happen if it's a basis for a rational inference. And with respect to intent, that evidence, if it's going to be supportive of a finding of intent beyond a reasonable doubt, must be specific to the intent that's associated with the crime that is charged. Here, to the extent what we're talking about is the statement of the defendant to the police. That was about knowledge, pure and simple. It had nothing to do with intent.
So when you're saying the defendant says, "You got me," right, it might mean you got me intending to pass counterfeit money, or it might mean you got me with counterfeit money, and we can't draw any inference that it's one or the other. Is that what you're saying?
Well, here in this case, the statement that was provided by the defendant to the police was that, let me talk to a detective. I'm willing to make a deal, and I will tell you who I got the counterfeit money from if you make the drug charges go away. That statement, at best, indicates knowledge, but not an intent to defraud. Also, with respect to the testimony that the Secret Service agent provided, that too also cannot go to intent because it was not based on anything. There was no foundation, and it was improperly omitted because it provided a false sense of authority.
When was the first time that defense counsel made an objection to that foundation known to the court?
The first time that objection was made was when the testimony was provided.
So I don't remember, was he or she, when counsel said objection?
Correct, Your Honor, yes.
Okay. Is that enough to preserve that argument?
Here it was. If you look over the course of what happened at trial.
How would the court have known that that was the particular objection?
Well, first of all, at that very moment in time, there was a very specific and discrete testimony that was being provided by the Secret Service agent. It was purely and solely directed to the question of how do people who are caught passing counterfeit bills at the street level commonly behave? And so there could have only been one reason for the objection that defense counsel launched at that very moment. But further, if you look over the course of what happened at trial, in response to the trial judge inviting counsel to provide exceptions to the jury charge provided, defense counsel made very clear on the record that the reason for the objection at that time was because of the Secret Service agent's lack of qualifications for being able to opine on how those who pass street level, those who are passing counterfeit currency at the street level would typically behave. That's very clear on the record. He says that's part of the reason why I made the objection. I see that my time is up.
Thank you, counsel. Counsel?
Good afternoon, Your Honors. May it please the Court. My name is Sheila Bautista, and I represent the people in this case. Your Honors, multiple factors supported the jury's rational conclusion supporting the defendant's intent to defraud with the counterfeit money that he possessed in this case.
Would the evidence be sufficient without the agent's testimony?
Yes, Your Honor.
Okay, what's the other, assuming the agent's testimony is out, what's the other evidence that supports that reasonable inference by the jury?
Your Honor, the agent testified that it was common for people to separate the money. In this particular instance, the jury could still consider that this individual defendant wrapped the money in a rubber band so that he could feel it in his pocket and distinguish it from the real money in his pocket. There is the fact that he had 17 counterfeit.
So if you were trying not to pass counterfeit money, but you possessed it, how would you keep it?
You could.
Would you mix it with your regular money?
No, you wouldn't, Your Honor.
So why is there any probative value of the fact that he separated it? If what we're trying to determine is, does he have an intent to spend it?
Correct.
And whether he intends to spend it or he doesn't intend to spend it, he's going to keep it separately. Why can we draw any inference from the fact he kept it separately?
You could draw either inference. Either inference could be rational.
Couldn't you draw no inference from that fact? If two things are equally possible from a fact, how can you draw either inference from them? You're saying you can draw both, but there are facts that are probative of nothing, right?
I can't think of one right now. We know what the jury inferred in this case. We know what the jury inferred in this case, and it was a rational inference. It was a reasonable inference.
So your
Given
view
the
is even
standard
if,
of having to look at this in the light most favorable to the people, they're entitled to that inference.
They're entitled to that inference.
Yeah, but again, my question was, if we take out the agent's testimony, which
Correct.
she disputes, what is left?
We have 17 bills, 17 counterfeit bills amounting to $300.
So is there something magical about the number 17 as opposed to the 3 bills that's in Bailey, or, you know, like
It's more than the bills in Bailey. There were 3 $10 bills in Bailey. 17 counterfeit bills amounting to
There are
$300.
other cases where way more than that has been held not to be sufficient,
Well,
right?
correct, but in this situation, the quantity of the bills demonstrates that this was not an accidental possession of the money, it was a purposeful possession. He did not receive 17 bills amounting to $300.
No, but I'm not asking about the possession, I'm asking about the intent.
Correct, so.
Fraud, where is that?
It shows that the number of the bills shows that the possession is purposeful. The purpose of it is to use the money. And based on the purpose, given the number of bills, given his purpose in wanting to use that money, that is probative of his intent to defraud.
Does it have to be a purpose to use that money in close temporal proximity to when it was discovered? In other words, does it have to be intent to use it, you know, that evening or whatever? Or can it be any time?
It can be any time, as long as there is intent. And in this and he was in a circumstance where he had opportunity to use that money. He was in a place, he was in
Well, you
Times
do
Square.
seem to be collapsing the possession and intent, because he could be just carrying it to give it to somebody else. Not for purposes of fraud, someone who realizes counterfeit, he's going to give it to them, they're part of some counterfeit scheme, who knows?
But that's a possibility, but that's not what this jury concluded. The jury made that rational conclusion based on the separation, based on the number of bills, based on the denomination of the bills. The denomination of the bills is also supportive of his intent to defraud because they're 10s and 20s. Those are subject to less scrutiny.
So
And given this
under what circumstances would someone who's in possession of counterfeit bills not
Not
that
intending to
possession,
defraud.
right?
Correct.
Not be able, the people could not proceed to show intent.
Well, there's Bailey, the 3 $10 counterfeit bills. If a person had, you know, a few $1 bills mixed up with, maybe he had 3 $1 bills mixed up with $100 in their wallet, maybe that's money that was accidentally acquired by the person, and in that
That means
situation,
you have
that would be
possession without
harder.
knowledge of the counterfeit bill.
Right, or
Let's say someone who has knowledge that they have counterfeit money on them.
perhaps someone got the counterfeit money in change during a transaction and wants to go back to that person and say, hey, look, this is fake money. They separate from the real money and say, this is fake money, but this money couldn't have been acquired in exchange. It's $300. It's $300, and there's no exchange where you would get $300 in change wadded up in a rubber band. So based on.
not from a drug transaction? He's found with drugs.
He's found with drugs.
People don't buy $300 of drugs in cash in New York City?
Right, but that's not.
also
that's-
be using to make change for the drugs transactions he's carrying out, but we don't know any of that. I have a question on the issue of how they actually get to him. I just want to be clear. Your position is that it's a mixed question.
Mixed question of law and fact, yes, Your
Law
Honor.
and fact.
Supported by the record.
But is there actually, I guess I'm just troubled by this notion that because you see something in a brown paper bag, that somehow allows you to start pursuing this person.
Well,
And Yeah, why don't you?
Based on the officer's experience, the reason people drink beverages out of a brown paper bag is to conceal the fact that they're violating the open container law. And based on that, an officer has a right to approach and inquire. In this situation, the police officer tried to approach the defendant, but he ran away. And so so to inquire of this defendant, the police officer had to pursue. And that's what happened in this case.
Well-
Did he run away?
Did he run? Yeah.
Did he run away?
Yes, according
I
to,
don't mean once he's inside the building. I mean, did he run away the moment he saw the officer? Is that the beginning trot?
when the officer made a U-turn in his marked police vehicle, the defendant, on page 62 of the appendix, ran up the stairs. The police
Is
officer.
he already inside, or you mean external stairs?
He's outside. I don't know where the stairs are, but it sounds like he's running up the stairs into the haunted house to get
Well,
away
I
from
thought
the
you
police
just said you don't know
officer.
where the stairs are.
It sounds like he's running up the stairs into the, he was on the sidewalk, and he's running up the
Sounds
stairs.
like, but there's not a particular language you want to point to that
It's on
makes it
page,
clear?
it's on page 62 of the record that the defendant runs up the stairs into the haunted house.
So you're saying that he didn't have a right to, when he sees the officer, just walk away? I mean, it's not like the officer ever said, "Stop, I want to talk to you about your beer," or Limerita.
Well, given, sorry, could you rephrase the question,
Sorry.
please?
What I'm getting at is, you're partially relying on the flight, and there's a lot of cases about the sort of equivocal nature of flight evidence. So I'm not.
Well, flight, but it is this court's standard, well-settled standard, that suspicious circumstances, when combined with flight, can support a level 3 encounter. And in this situation, the police officer testified that based on his experience, and according to the judge, based on his on common knowledge, everyday experience, and plenty of case law throughout the country
So
in the Second
before the
Circuit.
flight?
Before the flight.
Before the flight, what level is it?
Before the flight, it's level 3. There's the brown paper bag.
Before the flight? So
Before
you
the
don't
flight.
need the flight?
We don't need the flight, but even without the flight, let's say that the brown paper bag, drinking out of the brown paper bag, let's say that's level 2. Let's say that gives the officer the right to inquire. In this situation, the officer didn't have an opportunity to inquire because the defendant ran up the stairs. And I would also like to point out that in my adversary's reply brief on page 27, they cite that the defendant was walking down the hallway. That is from the trial testimony. That is not from the suppression hearing. So there is no evidence from the suppression hearing that the defendant didn't flee. There's on page 62 that he ran up the stairs, page 72 that he was.
May I ask you exactly, what is it that, the people's argument?
Correct.
What is it that the defendant is doing that triggers that idea, oh, I think they're violating the law? Is it that it's a paper bag?
He's
So if it was a
dri-
plastic bag,
He's
it would not be
drinking
the
out
same?
of, he's drinking out of a bag that is concealing what he is drinking. And the reason people can see what they are drinking is because they want to hide the fact
As
that
long
they're
as it's
violating.
opaque, paper, plastic, doesn't matter. As long as you cannot see through it to identify
con-
what someone is consuming.
It's the concealment. It's the concealment of the violation of the open container
So if you
law.
have your drink in a, what do they call those, cozies? I'm not a beer drinker, so I don't know, what do people
Well,
put their drinks in?
that is usually, my understanding is they cover drinks, alcoholic beverages.
Oh,
It doesn't conceal the fact that they're drinking alcoholic beverage. If I could say one thing about the expert testimony, that was
But they're not concealing an alcoholic beverage because it is an alcoholic beverage? Is that what you're trying to say?
my
It's obvious that it is an alcoholic beverage?
Correct.
So if I'm a police officer, I see someone with one of these cozies, I don't drink either, I'm not sure exactly what we're going to, but let's say you seem to know, everyone else seems to know. I'm an officer, I can just go right up to them if I see the cozy?
Well,
It's equivalent to seeing this opaque bag?
if the officer sees the cozy, if it's obviously an alcoholic beverage, then that's probable cause.
No, I
that he-
assume the question was that somehow it's covered, you can't really see what is within the cozy.
Well, then it's equivalent to the brown paper bag if it's concealing what that person is drinking, and the reason why a person would conceal it is
If they drank with a straw,
you're still concealing the beverage.
And if it's a water bottle that you can buy at a store, not a Poland Spring bottle, but one of those reusable ones that is opaque, I'm drinking that on the street.
If it's not covered by a brown paper bag.
Well, you
Like,
can't tell- you can't tell what's inside it.
it's not a, if it's not a common, in this officer's experience, it was what a person, it's what people commonly do to conceal their alcoholic beverages. And in that situation, I don't believe that that's something that a person would commonly do to conceal an alcoholic beverage. But in this situation, you had the police officer's testimony. If I could say one thing about the.
Can I just ask you for a moment? Look, since you said it's not a level 3, so the officer sees this. Let's say the defendant didn't move, stayed there, stopped drinking out of it,
Right.
but didn't drop it, just stood there,
Sure.
didn't do a thing.
Yeah.
Officer comes up, officer asks, whatever the officer asks.
Sorry?
The officer comes up
Okay.
and asks perhaps a series of questions, but let's say one of them is, are you drinking alcohol? And the person says no. And the officer cannot see inside the bag. Now what happens?
Then I think that perhaps that encounter might have to end, but that person.
So the people's position, just the bag that suggests that you're concealing, based on the training of the officer, common sense, you're concealing alcoholic beverages, all it allows is to inquire.
You can stop and ask.
Yes,
Stop and
you
ask.
can inquire, but you can't do anything else.
In this, you can stop and ask in this
If
situation.
they say no, there's nothing else you can do, unless you smell alcohol. We'll take out all of those things, that there's nothing else that suggests there's alcohol in the can you can't see. Is that a no? If you're having that much difficulty, I assume the police and the individual would also.
Okay.
Counsel, do you care to finish your thought on?
On the
this?
expert testimony, yes, Your Honor. That was unpreserved, it was unelaborated at the time that the expert was on the stand, and by the time it was elaborated more, it was well after he had left the stand. There wasn't an opportunity to elicit any of the qualifications. The evidence had closed. There had already been summations. And also, I'd like to point out that the NYPD officer testified on page 137 that it's standard operating procedure for the NYPD to contact the Secret Service about counterfeit money cases because they are the experts on counterfeit money cases. This expert had 3 years of experience as a Secret Service agent in the counterfeit money squad. Based on his knowledge of how people make money and what they do to pass off money as real, that gave him the qualifications to provide the testimony that he provided in this case. Thank you, Your Honors.
Thank you, counsel. Counsel?
I'll pick up where counsel just last left off with respect to the expert testimony. The objection to the expert testimony being admitted into evidence was indeed preserved in that defense counsel provided a specific objection explaining that there was no foundation for being able to testify about how people pass counterfeit currency at the street level in response to trial court's invitation to provide exception to the jury charge. But setting that aside, whether or not the issue is preserved and whether or not the Secret Service agent's testimony was properly admitted, the fact of the matter is that there was complete lack of foundation for the expert's testimony, and therefore, and it only highlighted the insufficiency of the prosecution's case with respect to intent. And for that reason, we ask this, and all the other reasons that were provided in briefing, we ask that this court reverse.
Counsel, can I just ask you to address the Bourgh issue?
Yes. With respect to the Bourgh issue, last night, I ordered a burrito for dinner, and actually it showed up in a brown paper bag, a bottle-sized brown paper bag, right? So let's say I had decided to go out and eat that burrito late at night outside of my hotel room because I wanted some fresh air. So if you take the people's position to its logical conclusion, what that means is it very well may be that an officer passing by would then be able to physically tackle me in order to figure out what's in that brown paper bag. That just cannot be the law.
You're talking about if you're just walking along and carrying the bag? Not,
No, had I been taking a bite from the burrito with it still in that bottle-sized brown paper bag,
okay,
right?
but not if you're drinking. What if you're drinking?
Okay,
Is
let's
that
say I was
different?
drinking a can of soda that had been wrapped up in a brown paper bag by the bodega that I purchased it from.
Right, so the question really is the fact that the officer may have been wrong does that go to his right to inquire because of his experience that's often what happens in certain circumstances?
Well, in that instance, then he may have been within his right to make an inquiry. He was not within his right to do was to basically go from 0 to 60, right? To go and follow somebody and then escalate.
Unless the fleeing increased the level of suspicion, right?
But the flight here cannot be Mr. Britt's choice to avoid a police encounter under these circumstances, in this case, cannot be sufficient to raise the level of suspicion and the justification for the police encounter which was an immediate escalation and physically aggressive.
But do you agree that we have to look at this as a mixed question of law and fact? And if the answer is yes, how do we get beyond what the appellate division's findings were or conclusions were?
Here, the analysis doesn't involve a mixed question of law and fact because there was no minimum showing made. There is no record support for the finding that there was, that there was an increase in the level of suspicion that would have justified a level 2 contact and raised it to a level 3 contact. The fact of the matter is, these facts were very thin. The people have not cited to a single case where the mere presence, the mere use of a brown paper bag could justify a level 3 intrusion.
But do you agree it's a level 2?
Most.
Before the defendant leaves?
Perhaps at most, it could have been a level 2.
What was preserved below? What's the argument below?
The argument below that was made was that at most, it would have been a level 2 intrusion. And here, even if that were the case, though, there were no additional circumstances or observations made by the police officer that would have justified raising a level 2 intrusion to a level 3 intrusion. There was nothing to suggest that the defendant had been engaging in any kind of public inebriation other than the fact of the brown paper bag. But there is no case. There has been no case cited, and there cannot, because it doesn't make any sense, where just purely looking at the brown paper bag would give you justification.
Was there any evidence as to whether or not anyone else in the area was also holding a brown paper bag?
There was absolutely none of that, Your Honor. And to that end, there was nothing to suggest, there was no slurring, there was no stumbling, there was no indication whatsoever what was in the bag. And in fact, the officer conceded during his testimony that he had no idea whether it was a bottle or it was a can that was in that brown paper bag. And I see that my time is up. Thank you.